Hello, Mark Chastain, surveying 4465 class. My name is Kyle J. Levstek. I'm with Callaway Title and Escrow. I'm a commercial real estate attorney, and I'd like to talk to you all about something that matters an incredible amount to me, is legal descriptions. I've said for a long time that title and survey go together like peas and carrots. What my firm does, is we go to the courthouse and we research the title for 50 to 60 years here in Georgia. We put together a composite title report, and then that report goes off to buyers and sellers, clients, but most importantly, it goes to the surveyors. The surveyors that we deal with in this market take that data and also go to the field and put together something you guys are likely very familiar with, being in surveying 4465, the survey of the property, whether that be an Alta survey, a Georgia type land survey, a boundary survey, or the like. Those are the products that are typically prepared. But one of the elements of that survey, if not the most important element, is the legal description. It's something that people in my field deal with every single day. We review daily. It's a rite of passage in our office. When you start out, and one of the first things you do when you become a landman, as we are, or a conveyancer, or a legal assistant in the firm, is you sit down and you read a legal description to another in the office who will have the survey laid out and who will be going around the property mapping out the calls. The legal description is one of the things that causes the most consternation in our industry, because that's where a lot of defects exist. And it's really when property goes from bigger to smaller and new legal descriptions are created, it's something that having an ability to analyze, to create, to construct is incredibly important. And I know a lot of you know that with your experience in whether it be engineering or the classes you've already taken. But I'm going to go over a few of the finer points of legal descriptions from a real estate attorney. Professor Chastain, who is a good friend of mine, a longtime presenter. Anytime I present on surveys, I do it with Mr. Chastain. He's been on just about every panel I've hosted, just about every seminar I've done, because surveying is so important. He's an expert in his field, but also he's somebody that I trust and a friend when it comes to these things. A lot of times I'll have another client survey, a competitor of his survey, and I'll have questions. I'll go maybe attack the issue with those guys, and Mark will be a sounding board for me to review and balance it out with some of the questions that I have with regard to those products. But we're supposed to be talking about legal descriptions, and let's do that. First of all, Mark will say this a lot, Professor Chastain will say this a lot. When we presented it, he's mentioned it a lot. But a survey, a legal description, is like a journey or a road trip. Like when you're going somewhere, you pull your map out. The map is a survey. The directions would be, or the legal description would be like the MapQuest calls, point-by-point calls to get somewhere, the turns that you have to make along the way. You begin here at home. You go up the road till you hit the cross street, and you turn right and you go a certain distance, and you go here and you go there, and by the time you get done, you're back at home. As with most journeys, end up coming back to home. At least Joseph Campbell thought that. So legal description is no different. It begins with an origin point. It has directions to take us and brings us always back home. A lot of times, the biggest problem we encounter with legal descriptions is that origin point or point of beginning. And a lot of surveyors have a hard time drafting that. Sometimes in our industry, it's vogue nowadays to begin at like a state plane coordinate that are, points that can be defined using science and technology that you guys are likely used to. The problem for us land guys is there's no database of those points in the deed room. The way points of beginnings were defined were things found in the actual world, the terminus of two roads, or a landlocked corner, or a landlocked line in a road. Some older legal descriptions will have things like where the road meets the creek and things like that. But whatever the point is, the point of beginning, it has to be findable for those in the field, and a lot of times it has to be able to be in the legal descriptions of the past. So let's say we have something beginning in a landlocked corner, your origin point. Well, it can be a point of beginning, but a lot of times it's that point of commencement, and you'll leave that point of commencement to go to the point of beginning. But all legal descriptions must have that origin point. That's one of the most important things. And like I noted before, it's something that we see a lot of errors in. Some surveyors will try to use those state plane coordinates as being the point of beginning. And like I said before, title insurance companies in this market, and there's just not enough legal support for that to be an accurate point of beginning or commencement. It can be a reference point where you have the point of beginning being at two roads, and then give the state plane coordinates, which is helpful, and maybe something we're able to use down the line. But the current state of affairs, the state plane coordinates are not a valid point to begin a legal description from. So let's say we begin one at a good place, like the terminus of two roads, the north, the beginning at a point on the north side of Smith Street and the west side of Jones Street, and then running along Jones Street so many feet north, to another point, and then leaving the right of way and going east. Those are descriptions, those are calls the legal description must have. So the origin point is incredibly important. It's where the legal description begins, and you guys, as hopefully future surveyors and future drafters, will take a lot of care in preparing that legal description, especially the point of beginning. One of the things that you guys need to know with regard to the legal description, and I'm looking at my notes a little bit, so if I look down, I'm looking at my notes. A lot of times folks will want adjacent owners referenced in the legal description. As a matter of fact, it may even be a requirement of the guys that hand out the survey and seals. We have a problem with that because a lot of times the field work that you guys do, that is called into question legally when referencing adjoiners in legal descriptions. It's something that we always try to avoid, because if you have a call that leaves a right of way and runs along the land of Mike Smith 1,000 feet to a point, what's the most important call? Is it the line that you've measured from leaving the right of way to the point, or is it along the lines of Smith? And what if the line of Smith is not in the location that you've surveyed? That can cause a lot of confusion with regard to legal descriptions. As a matter of fact, there's some cases in Georgia that contradict, that don't hold our measured line to be the key line. There's some cases that say that the reference data would be the determining factor. So one of the things we like to do in legal descriptions is to let the work that the surveyor does stand out front, and to not have a lot of referencing material cloud your legal description. One of the things that doesn't cloud it is like saying along the right of way. That's a great point. So if you begin at a point of beginning and leave it and go north along the right of way, that's a great point. And then when you get to that point and leave the right of way, reference that in your legal description. As much data as we can have in the legal description is good, and I know that's kind of contradictory with me saying we don't want reference data that references other deeds or other title products in there. What we want in a legal description is the field monumentation, the items you find in the field, but also leaving the right of way, running to natural points found in the field. But what we don't want to have is a bunch of reference to other legal documents in your legal description. The whole point of a legal description is to take what exists out in the world that you guys draw on a survey, to be able to include it in documents and to describe that property, describe that physical property that exists for conveyancing purposes, to put into deeds. And that's what we do. We file these deeds all day long. We file these documents with legal descriptions. So we've got to be able to not only review that data, but also see how it affects the title to the property being conveyed. And that's why surveys are so important. That's another reason that legal descriptions are so important. Meets and bounds description the legal description should have a number of things. It should start with a caption that includes the county, the land lot, the district. If you're in the militia district, the militia district. It should include an actual description of the property. and acreage and square feet if you can, and include any less than accepts that, again, if you're doing a survey, most of the time you don't need to reference the less than accept because what you've surveyed includes the property that currently exists. You don't need to survey a greater property than take something away by another reference. But it's good to say that the legal description could have less than accept. Some older legal descriptions will say subject to and have exceptions of title built up there with the legal description. Georgia's kind of loose as to what a form of description has to be. Sometimes you'll see omnibus descriptions that'll say property could be the entirety of a land lot. You can go and look at the records in Jackson County, Georgia, and find out the land lot was say a 280 acre land lot, and those land lots had dimensions, and the corners can be noted, so the property is that land lot corner. A description can be limited to that. A description could be also limited. It doesn't have to be a meets and bounds description. It can have that caption, all that tractor parcel land lying in land lot 103 Cobb County, being in Cobb County, land lot 103 2nd District, being depicted at a plat recorded at Plat Book 7, page 109. And then the survey that was recorded, in my firm, we're a little funny. There was always kind of debate. A survey is a plat, and a plat's a survey, but some people would say that a recorded survey is a plat, and that a plat is a survey that happened to be recorded. Those words are interchangeable, but in the conveyancing, we refer to it as recorded plat, and that's the nomenclature to describe surveys that have been recorded in the county records and can also be referred to as such. And just before I finish up, I want to talk about drafting legal descriptions. Make sure your caption is clear. Try to avoid typographical errors. Try to clearly define your point of beginning. Let's see. Just always imagine that somebody's coming behind you to look at this legal description. I know a lot of times the survey. You spend so much time. You guys are craftsmen. You create a beautiful product. Guys like me love to review them. But that legal description is what takes that product. So many people will never see your survey. So many people, the only fingerprint of your survey will be that legal description. So I want to encourage you all to take a lot of pride in drafting it. Because if you take a lot of pride in drafting it, you include a lot of data inside the legal description, you take time to avoid typographical errors. When we do the documents, when we create the documents and the conveyancing is done, it just makes for a better product. Like I said at the beginning, title and survey go together like peas and carrots. Your conveyance attorney, your real estate attorney, and your surveyor, there should be no consternation when you have situations with the surveyor and attorney. There should be harmony at all times, even when we disagree. Even when I look at a legal description and Mark's done the survey and I say, this doesn't make sense to me. I've been in many conversations with surveyors where they say, well, they'll go to the field and they'll have problems and we'll end up talking the issue out, and they'll want to hold to something true with regard to the survey or the legal description because that's how their training taught them how to do something. My training may have led to a different outcome or interpretation of the data that we're given. That's okay. We don't always have to be in direct harmony. What we've got to do is be able to work together to try to best describe the property being conveyed. And that's the way that a real estate attorney and the surveyor can work hand in hand. But we were talking about drafting descriptions. So make sure your caption's tight, avoid typographical errors. Any footnotes that are great. We love to reference not only when we do the surveys, we like the acreage to be referenced. We love when the square footage is referenced. We also like the surveyor to be referenced because a lot of times that's, again, a fingerprint. You put your name in there. And surveyor is one of the few professions too where you're given a seal, you seal and sign everything. So, if I get a survey, it's not signed or sealed, it don't mean too much to me. I want to see your name on it. I want to see your seal on it. But that's also a way that I could track you down and communicate with you with regard to surveys done in the past. And as you go into this business, it's also a way to get a lot of business because a lot of people look at that legal description, just hire the surveyor who did the last survey. So that's another good aspect to it too. let's just talk about some guidelines and recommendations for legal descriptions. Point and beginning need to be in all caps and bold. Don't be